Mr. Otieno, you are for the accused person?
Yes, I'm for the accused person, Your Honor.
Yes. For the state?
Yes, Your Honor.
Your Honor.
Get the direction of the court, specifically the fact that there is an anticipatory bail that was issued by the High Court in Milimani. Your Honor, the order is dated the 4th of February 2026, issued by Honorable Lady Justice M. Muigai. I have submitted the application and the order before the court. We're requesting that before the plea is taken, a direction be issued, especially going with the fact that the decision emanates from the High Court.
The order was issued on the 4th of?
The 4th of February 2026 through an application.
That's okay. The order is here.
That's okay.
Mr. Mwai?
Your Honor, the prosecution has become aware of the said anticipatory bail just now, Your Honor, in the court. We submitted that, Your Honor, proper disclosure was done, Your Honor, to the state in good time to make us, Your Honor, respond. And also not to establish whether or not it relates or not to the current matter. Because we believe that a suspect may obtain anticipatory bail based on different investigations that are undergoing on against them. We cannot therefore ascertain whether it relates with the matter before court. I don't wish to inform court that these charges were fired last week, and therefore now, if the same is in place, it's overtaken by us. I don't pray that we proceed with the plea taking. Also, I'd forgotten, and also based on the sensitive nature of this matter, which has attracted both public interest and also international interest, we don't want to believe that it is employed by the defense to try to scuttle these proceedings. We pray that we proceed with the plea taking. Then we give time to respond to our applications regarding our own terms.
When I rejoined at the same, the supporting affidavit that has been brought before this court the application, Your Honor, it is supported by an affidavit of...
Your application before the High Court?
No, I'm talking about the supporting affidavit that has been brought before this court.
An affidavit to oppose bond?
Yes.
Yes.
Sworn by PC Robbie Stella.
Mm-hmm.
Clearly indicates that they had a conversation with the accused person. It is on record that indeed they had some conversation. So, if they had time to look at the witness statement, perhaps have a conversation with this accused person, then the prosecution wants you to believe that they are not aware, but they are aware of all facts they have put on that supporting affidavit. Your Honor, the High Court has a jurisdiction on anticipatory bail, and the only way to vitiate anticipatory bail is to show there's an illegality, or even for them to prove that they're likely interference with any witness, there should be evidence, as was stated by Honorable R. Korir, in R versus Jordan Mayenda and 3 others, 2012. There should, it is not about
Can we limit
passivity.
ourselves to what is before the court?
Yes.
Let's not veer off.
Yes, Your Honor. I'll
into
state
other- into
clearly
other. So
and
let
state
me
that.
let me just go to the point, the issue that I have the order with me here.
Yes, Your Honor.
The order is dated 4th of February 2026.
Indeed, Your Honor.
That the applicant be and is hereby admitted to anticipatory bail of 100,000 shillings
Correct, Your Honor.
during the pendency of investigations.
Yes, Your Honor.
That the applicant shall not be arrested in the intervening period
Yes.
in connection with the investigation alluded in the matter.
Correct, Your Honor.
So those are the orders.
Those are the orders, Your Honor.
And so can you give me your interpretation of those orders? Do they mean that the respondent will never be arrested?
Not really, Your Honor.
So
There's a
when
mention.
it says the intervening period,
Yes.
what does that mean?
In the intervening period, and I'll still go back to the affidavit that has been sworn by PC Stella. She has stated clearly the investigation are still going on. It is here, Your Honor, on record. Unless they have stated that you have completed the investigations, now we have gone back to the court where the orders for bail had been issued, and therefore you have done what? You have moved away from those orders.
Now we have an order here,
Indeed,
anticipatory bail.
Yes, Your Honor.
It says that in the intervening period, the accused person shall not be arrested.
Yes.
What constitutes the intervening period?
The intervening period until 27th of March, when he is going back to the High Court before Honorable.
So the intervening period is until the 27th of March.
Indeed, Your Honor,
in your
unless that
interpretation.
court,
So
unless that court extends.
between the date of this order and the 27th of March,
Very true.
no arrest
Yes,
is
Your
to happen. That is your
Yes.
interpretation.
Yes, Your Honor.
Okay, and it talks about shall not be during the pendency of the investigations.
Yes, Your Honor.
What investigations are referred to?
Your Honor, at paragraph 7, investigation are still ongoing and the accused person is
No,
likely...
it's just referring to
let me
our
just
affidavit.
respond.
I will not allow that, Your Honor.
Yes.
This is our affidavit.
Your Honor,
Yes.
the investigations are still ongoing.
Which
Your Honor is referring
investigations?
to an element in our
I'm
affidavit.
asking a very simple question.
Yes.
These orders, the ones by the High Court, were
Yes.
granted in a particular context.
In the, Your Honor.
I want to understand the context in which these orders were granted. What investigations are being talked of?
Your Honor, I am guided by my client that number of times the officers of the,
What prompted you to go to the High Court to seek these orders?
that's what I'm trying to explain
Yes.
to court. A number of times the members of the DCI, NIS, reached out to my client asking on some issues that they thought he was involved in. Your Honor, if you look at the affidavit that has been sworn by him, Your Honor, you'll see the affidavit is dated the 11th of April 2025. It is attached. And if I can read in verbatim, like 3 clauses, that I am a director and shareholder of Global Face Human Resource Limited, the company which is involved in the employment agency, Manpower, with its offices located in Nairobi. That on several occasions, the police officers have threatened to arrest me due to undisclosed reasons. Your Honor, even if I was just even to end it there and go to the charge sheet that will be presented here, it deals with some transportation or some recruitment. And that is the reasons why that bill has been issued.
So what are you asking the court to do today?
I am asking this court, Your Honor, that the case that has been brought here will be a violation of my client's rights.
And so therefore the court should?
The court should stand down until the orders are issued by Honorable Mungai on the 27th of March 2026.
Okay. Now, I hear what you're saying. And just as the prosecutor has said,
Yes,
that
Your Honor.
these documents have just been given to him,
Yes, Your Honor.
the same is the case with the court.
Indeed,
I've
Your
just seen the documents for the very first time right now.
Yes, Your Honor.
And so we are not on equal footing
That's indeed.
with yourself. You have much more information because it is your own application. You come with a lot of background information, which the court doesn't have, and apparently the prosecutor does not have. And so the court is grappling with very basic questions right now to try and get itself into the frame of mind to understand where this thing is coming from and what is the purpose and the purport and what does the High Court order entail. Now, just looking a casual glance at your ex parte chamber summons, I note that the main orders that were sought are prayers number 3, number 2 to 4, 2, 3, and 4. Allow me to read them quickly. The applicant to be granted anticipatory bail before arrest and or charge. So anticipatory bail before arrest or charge. A day be appointed for the applicant to appear before the appropriate police station or the Criminal Investigation Department headquarters together with his advocate to enable the police undertake investigation without taking the applicant into custody. So that was the second prayer. And thirdly, a day be appointed for the applicant to appear in court for purposes of charge and trial if criminal charges are preferred and filed in court against the applicant.
Very true.
So from your own application, it would appear that you made allowance that the applicant should appear in court for purposes of taking plea should criminal charges be preferred against him.
And Your Honor, that is why there's a mention before the court that issued the said orders so that they can, the DCI and the respondents have been mentioned to respond.
How does he find himself here today?
He surrendered so that he can come and meet the officers of the DCI.
And he
was not arrested.
He was not arrested.
He was not arrested.
So he was brought here.
In fact.
So we can agree that he has not been arrested. Now, can we agree?
Yes, Your Honor.
Can we also agree? I'm just trying to get something very clear.
That's true.
I believe, and this is my understanding, that the orders of the High Court were to bar the investigators from holding him in custody during the investigation. Now that investigations have been concluded, is there anything in the orders that says he cannot take plea once he's charged before court?
Your Honor, then I'll be waiting for the prosecution to present the affidavit.
And then
that
you
is
can
there.
make your argument.
Then now I can raise my issue.
Yes,
thank you so much.
I think we agree now. Mr. Moy?
Yes, sir.
I thought you wanted to say something.
Yes, sir. Your Honor, I just wanted to bring to the attention of the court that the communication between the investigator and the accused person pertained his security, Your Honor. Because, Your Honor, through WhatsApp messages between Sergeant Saima, the investigator, he indicated that, Your Honor, he was willing to surrender to the Kenyan authorities after being pursued, Your Honor, by the Russian authorities. So he was willing, Your Honor, to surrender himself, Your Honor, and be presented, Your Honor, before court. Your Honor, you have printed a copy of that printout, Your Honor, of that communication.
Okay, so yes, I think we are at a consensus, Mr. Otieno.
Yes, Your Honor.
That my understanding, my reading of the High Court order, is that the accused person, your client, was not to be arrested by the authorities during the investigations. But those orders do not extend to saying that charges cannot be preferred against him or that he cannot stand before a court to answer charges. That is my reading. And secondly, I find that reading is even supported by your prayer number 4, which says that he be presented at court should their charges be preferred. So that once we are done with the charges, then we will argue the issue of bail and bond. That is my understanding of the whole issue, and that is what I'm going to put on record before we can go on to the plea.
Your Honor, first, to respond to my colleague's arguments, that he's producing an extract of conversation. Your Honor, Section 106 of the Evidence Act is quite clear on presentation of documentary evidence. Therefore, that piece of paper should not even see the light of day.
You know, I'm not producing.
He's on his feet. He's on his feet, Mr. Moy. Please allow him to conclude.
Number 2, Your Honor, as long as there's a court order from the High Court. And that is my prayer.
Yes, yes.
As long as there's a High Court matter
Yes.
stopping the arrest of the accused person, Your Honor, this court does not have authority to sit and hear any plea taking. We can wait,
Yes.
and this is my submission, we can wait until 27th. The person surrendered for investigation, for questioning.
Yes.
And I know even them, they can produce any statement from the accused, if there is, showing that I have given this statement to the prosecution, please now go ahead, you have heard the side of my story. Investigation emanates from Article 50 of the Constitution on the right to fair hearing. Article 25 of the Constitution says that we can never abrogate the right to fair hearing unless he has been given the opportunity to write a statement showing that indeed I have participated in the investigation. Your Honor, his side of the story has not been heard. We cannot conclude an investigation with one side of the story, Your Honor. It has never happened. It is a violation of his human rights under Article 49 of the Constitution and Article 50 of the Constitution. There is no way the court will hear any plea if there is a court order, and yet he has not been heard. He just presented himself this morning.
Now, thank you, Mr. Otieno.
Thank you.
And this is what I've said, that I have listened to
Yes, Your Honor.
what you have said, I've listened to what the prosecutor has said, and I'm entitled to have my interpretation
That's true.
of the whole issue, which is what I'm giving, and then based on that, you could agree or disagree with me.
That's
and
true.
when you disagree with me,
Yes, Your
then
Honor.
you go back to the judge and you say,
Indeed, Your Honor.
these
We stand guided,
did
Your
not
Honor.
understand
Thank
what
you so
said.
much.
Thank you.
Thank you.
Now, Mr. Otieno,
Yes, Your Honor.
I am going through the application
Yes, Your Honor.
and I see that the orders
Yes.
were given on the 3rd of June 2025. The orders of the High Court were given on 3rd of June 2025.
Indeed, Your Honor. But signed on the 4th.
Just a moment, just a moment.
Yes.
So they were given on 3rd of June 2025. I also see that the application that the orders emanate from High Court miscellaneous case number 110 E110 of 2025.
Yes, Your Honor.
The copy of the application that you have submitted to the court,
Yes.
unfortunately, I've gone through the entire document. It does not bear the number, the miscellaneous file number at the top, at least the one that we have here. So I'm not sure whether this order
Your Honor,
and this
listen.
one.
We can, as an officer of the court,
Yes.
I can confirm
Yes.
that indeed this is the order, and I stand with
I
it.
do appreciate, and I know that you cannot mislead the court,
Thank you, Your Honor.
but I will be much more comfortable
Yes.
if you can give me a copy
Yes.
that was actually filed, which has filed the
Your Honor,
number.
will be requesting for a break for 10 minutes.
We will do that.
For me to be able
so
to-
I need that.
Yes.
I need a copy that actually has
Thank you so
the
much, Your
number.
Honor.
I'll grant you the 10 minutes
Thank you so much.
that
Your
you
Honor.
request,
Yes.
so that then I'm able to go through both documents and as I put down my thoughts
Thank you so much,
in
Your
the
Honor.
form of a ruling.
Thank you.
Good. So we'll place the file aside for 10 minutes. Please do avail
Yes.
copies that are clear
Thank you.
and that have the file number.
Okay.
Do the same to the prosecution as well.
Thank you so much.